The presenter is Professor Jack Balkin, and the commentator is Professor Tom Merrill, but the commentator, as was true of one of the panels yesterday, the commentator will speak first.
Minutes. Okay. So I'm going to do something even more unorthodox than Michael and Randy did yesterday. I'm not only going to try to summarize Jack's very interesting paper, or at least what I regard as the highlights of it. But before doing that, I wanted to sort of offer a kind of framework of interpretational theories. And the framework, and then I'll try to fit Jack into the framework if that's possible. The framework derives from my own interests, which are more focused on statutory interpretation theory than constitutional interpretation theory. So I thought it might be worthwhile to at least throw some of the statutory stuff on the table. There's clearly a lot of overlap between statutory interpretation and interpretation theory and constitutional interpretation. They both involve enacted texts. They both involve issues about change over time and so forth. There are also obviously some differences between the two, and so clearly there's no direct one-to-one equation between the two. But one reason to bring up statutory interpretation is that I think that the statutory interpretation field, for those that haven't been following it, has gotten quite interesting. It's not just some kind of plodding debate between intentionalists and textualists, as one might get the impression by reading court opinions. There are a variety of theories on the table, and some of the theories that interest me the most are ones that have come out really quite recently, which I lump together under the heading of welfarist interpretations. These are interpretations or theories of statutory interpretation that basically invoke maximization of social welfare as the ultimate criterion for interpretation. And I think putting that on the table is something that the constitutional interpretationalists haven't quite gotten to yet. In any event, I'll frame it this way. I think there are three families of interpretational theory, which applies both to statutory and constitutional interpretation. The first family I would call faithful agent theories. These are theories that conceive of the interpreter as performing the role of agent relative to the lawmaker, who is the principal. Perhaps a better characterization would be a sovereign-subject relationship, that the enactment is seen to be an authoritative expression of the sovereign lawmaking power of the state. And the interpreter is seen as the humble subject of the sovereign, seeking to effectuate the command of the sovereign. I think, interestingly, you can actually trace this back in time to a period when literally laws were commands of the king, and everyone was a subject of the king, and the realm had a duty of fealty or obedience. The king then became the king in parliament, then became the parliament, then became the people, as sovereign, creating constitutions and legislatures and so forth. But the sovereign-subject relationship, I think, derives back to a very literal human relationship between a sovereign and the subject, and may be the roots of a faithful agent understanding of interpretation. In con law, faithful agent theories tend to be, I shouldn't say tend, I think they're all originalist theories, but as Jim Fleming's paper tells us, there are now 72 varieties of originalism, so the Heinz Ketchup Company has a way to catch up to us in terms of originalism. In statutory interpretation, the main divide seems to be between textualism, which sort of corresponds with original public meaning, and in intentionalism, which corresponds with sort of a purposive or intentionalist theory of constitutional interpretation. I won't say anything more about faithful agent theory since you're all kind of familiar with them. A second category, which I think are somewhat more prominent in the statutory realm than in the constitutional realm, but not unheard of in the constitutional realm, I would call integrative theories. These are theories, they do not conceive of interpretation as a sort of sovereign subject or principal agency relationship. They conceive of interpretation, the role of interpretation as a process of synthesizing a variety of authoritative sources of meaning, of sources which are not fixed at a particular moment in time, the moment of enactment, but rather are spooled out over time as different actors in the political system seek to attribute meaning to enactments. Integrative theories are not static or are not snapshots the way faithful agent theories tend to be, but rather have an evolutionary or dynamic quality to them. A variety of metaphors have been offered to try to explain integrative theories. Among my favorites are Justice Scalia's image of a broken field runner on a football field, twisting and spinning and stiff-arming in order to reach a predetermined goal. That's a very sardonic characterization. Or Ronald Dworkin's theory of the chain novel, in which every interpreter is adding a new chapter to an ongoing saga, trying to link things up with what went before. I think in historic terms, the model of interpretation, the roots of this model are pretty clearly the common law and the process of judging at the common law. So it kind of comes naturally to American judges to adopt this integrative approach to statutory interpretation by emulating the way in which common law rules of decision evolve over time. The task of the interpreter under this approach is to try to fit all of the data together in some kind of coherent covering law or explanatory hypothesis or rule of decision, and the goal is to make the theory or the explanation fit as much of the data as possible in the most successful fashion. Some examples of integrative interpretation, probably Ronald Dworkin is the most famous with his theory of law's integrity, also Bill Eskridge with dynamic statutory interpretation. Bruce Ackerman's theory of constitutional moments is a type of integrative theory, I think, and David Strauss, who is an object of Jack's criticism with constitutional common law. I would claim, going somewhat beyond the literature, that there are in fact two different types of integrative theories. The ones that are well represented in the existing literature are what I would call teleological, in the sense that they would have the interpreter knit together as much data over time as possible and then sort of cement it together with some type of moral theory or proposition about what the law should be or ought to be. So it's a highly moralized or a goal-directed theory of integration. I think there's another possibility, which I would call Burkean interpretation, which would seek to fit things together in accordance with the interpreter's best understanding of the status quo. In other words, what do legal actors in the current legal system actually regard as being the law right now, and which interpretation best coincides with that understanding. The third category, which I briefly mentioned at the outset, is what I would call welfarist interpretation. This is quite striking. It sort of breaks from the mold of the other interpretational theories, which are more or less concerned with trying to define a legitimate role for the interpreter in light of larger jurisprudential conceptions. And instead says, well, come on, let's just have interpreters adopt the meaning of the text, which produces the best consequences for society. Let's cut to the chase. The most famous, I think, or well-known welfarist interpreter is Judge Richard Posner, who's now written 4 or 5 very thick books trying to explain what he calls everyday pragmatism, which is, I think, what I would describe as a welfarist interpretation. You're bound by the text, but if insofar as there's room for interpretation, interpret the text to achieve the greatest net benefit, net benefit relative to costs for society. Is kind of a cost-benefit approach to statutory interpretation. Other interesting variants of this are Adrian Vermeule, who sort of uses considerations of comparative institutional choice and focuses quite intensively on information and the deficiencies that judges have in terms of information in order to argue for certain rules of interpretation designed to minimize the damage that judges do because of their ignorance about the social consequences of their decisions. Or Einar Elhauge, who has a very elegant theory, which argues that the thing to be maximized is current enactable preferences, sort of a current democracy reinforcing theory of interpretation. Anyway, that in my view is sort of the lay of the land in terms of ideal types or families of theories, and there's sub-theories under each of them. Now, how does Jack fit into this? Jack's theory, a very elegant little theory, and we don't have it all. We have one chapter in a book that I think he's working out. Jack sort of, to some extent, I think, draws on all three of these traditions in framing a theory of constitutional interpretation. The primary focus is the faithful agent idea. His method of text and principle, which yields something he calls framework originalism, is very much couched in terms of the conception of interpretation as being the faithful agent of the enacting body, in this case the polity which adopts the Constitution and its amendments. I regard Jack as making three very important key points in support of his idea of how faithful agent interpretation would work in the constitutional context. And many of these, I think, are extremely valuable and contributions. I found some of his explanations of these more persuasive than I'd seen elsewhere in the literature. One point he makes that I think is extremely important is that the text of the Constitution, like most enactments, I guess, speaks in different levels of generality. You don't just have grand abstractions, nor do you have a book of rules or narrow propositions. An instruction manual, I think Gary Lawson once called the Constitution. But you have a variety of propositions of varying generality with rules on one hand and fairly broad standards and principles on the other. And Jack's point is that the duty of the interpreter as the faithful agent, is that 2 left on my 13? Yeah, okay, all right, sorry. Is to follow the text. If the text adopts a narrow rule, like every state has 2 senators, then you follow the rule. And if the text adopts a broad principle, like equal protection of laws, then you follow the principle. And because of this, a very basic point, but one that I think is often overlooked, Jack derives a second proposition, which is that it's wrong to interpret standards and principles, broad textual provisions, in light of what he calls expected and applications. So you don't take something like the Equal Protection Clause, the Due Process Clause, and ask what did the people that adopted this language expect that to mean in terms of its application. And that is a mistake, basically, because if they had wanted you to adopt whatever they expected the applications to be, they would have written a rule instead of a standard or a principle, and they didn't do that. And so you're not really being faithful to the enactors of the original Constitution if you adopt the expected applications approach. I found out all that to be quite illuminating and persuasive. The third move he makes, which is a little bit sketchy in this chapter, but hopefully will be fleshed out some more, is that I think he's arguing that the choice of adopting broad standards or principles is in effect an implied delegation to future generations of interpreters to determine how those principles will be applied in different circumstances. Now, he carefully points out that it's not inevitable that broad language means this. It conceivably could be meant as a term of art, to use yesterday's discussion, incorporating certain narrower range of applications. And we have to look to history to figure out exactly what the intent, whether there was a delegatory intent or not. But Jack makes the argument that, in effect, we can view these broad provisions, many of them at least, as delegating authority to future interpreters. And in that way, faithful agent interpretation then links up with a more dynamic, integrative, or welfarist approach. With respect to integrative interpretation, Jack's treatment is largely negative. He He doesn't like David Strauss's constitutional common law, and he says some critical things about David Strauss, which I think are also well taken. The most telling point that Jack makes here, I think, is that insofar as integrative theorists like Strauss treat the precedents, the accumulated precedents of the court as the Constitution and try to demote the text of the Constitution to some lesser status of a focal point for decision making, that this is just simply inconsistent with some larger understandings that we have. He points out that narrow constitutional rules like the president has to be 35 years old and so forth are uncontroversial. Everyone follows them. No one suggests that we can abandon these specific directives in the Constitution. It would suggest that they're regarded as binding law in a way that the constitutional common law a la Strauss suggests there is no binding law in the text, perhaps. He also points out that there are very few contra-constitutional rulings. Maybe we can think of a few. I thought maybe this is not a ruling, but the practice of states allowing paper federal money to be used for payments of debts might be contra-constitutional. But it's true in general that there are very few constitutional understandings that are in fact inconsistent in the strong sense with the constitutional text. And so in that sense, the text is superior to our interpretations of it. And finally, he makes the point that, clearly the courts can't overrule the text the way they can overrule their own precedents or can change practices. Practices can change over time. So Strauss's sort of strong integrative theory that puts the text as background and makes the constitutional doctrine, the Constitution, has serious deficiencies. Down to zero. Okay. Jack on welfarist interpretation. All I would say here is that this is the least well-developed aspect of the chapter, and maybe later chapters will pick up on this. I think consequences do clearly matter for Jack. He does not want a constitution that means that to be a faithful agent you have to embrace the Lochner decision, and he would not want to commit to a constitutional common law or integrative theory that required judges to declare gay and lesbians unprotected by the Equal Protection Clause. So consequences clearly matter to him, but how in fact these consequences enter into his interpretive theory remains somewhat underdeveloped. So Jack, you'll be disappointed that I was going to list a bunch of criticisms of your paper or things that I thought required further development, but I've run out of time, I guess. Cede me.
I have 10, so I'll give him 3 if you can.
All right, real quickly. Okay. Real quickly, one point where I think you need to be a little more clear is that in the constitutional context, as we sort of saw yesterday, the big debate seems to be between specific and broad, or narrow and abstract, and you clearly come down on the side of the broad abstract principles and so forth. In the statutory context, the big dispute is between the intent of the enactor versus the plain meaning of the text. And it's a little unclear to me where you come down on this. Sometimes you make noises that seem like, yesterday in response to Larry Alexander, you seem to endorse his idea that in understanding the words of the enactor requires us to attribute some purposive understanding to those words, which makes you sound like an intentionalist, but there are some statements, certainly in your piece in Constitutional Commentary called Original Meaning and Constitutional Redemption, where you seem to specifically reject purposive understandings that were not bound by the specific intentions of the framers with respect to principles. And so maybe some clarification of that would be a good idea. The second point I would make is that if delegation is the answer, then you have to sort of address who the delegatee is. If you look at the text of the 14th Amendment, and the text is very big in your theory, Section 5 seems to scream out that Congress is the person that's supposed to be the delegated interpreter. There's not a word about the courts. You might say, well, in the history of the 14th Amendment, there seems to be an anticipation that courts would be the interpreter, but that's an expected application. That's not the text. So I think if delegation is going to be a big part of your theory, you need to focus on that question a little bit more. A third thing I'd say is that I think there is a danger of sort of sliding too easily from the faithful agent model to what I would call a pure welfarist model through the device of sort of implied delegation. And this has happened in the statutory interpretation area. Recent work of Frank Cross, which I don't have time to describe, is a perfect example of this, where you just sort of say, well, anytime there's an ambiguity, anytime there's a gap, anytime there's a broad principle, the enactor must have delegated to the interpreter the authority to make law. Therefore, the interpreter can act as a pragmatist or can act as a welfarist or whatever. And so you just sort of, you try to embrace the trappings of faithful agent interpretation while quickly leaping into welfarism as the actual operative principle. I'm not sure that that's really what you want to do, or that's not the thrust of the tone of your piece, but I think you need to sort of address a little bit more how one avoids just using faithful agent theory as a springboard to whatever it is that the interpreter wants the provision to mean. And in the interest of giving you some time, I'll shut up at that point, but thanks very much.